Hollenbach versus CLN4Ue 2015 ON SCSM by Kristina. Facts. Number 1. The parties, Ms. Hollenbach and Mr. CLN4Ue, had dealt with each other before. The plaintiff had contacted Mr. CLN4Ue before to have him install flooring in her previous home and was fully satisfied with his work. She contacted him again in 2013 in regard to this renovation project. Number 2. A quote for money was given orally by the defendant. The estimate for the flooring project was for $3,700 or more. By the time it was all said and done, the price was around $8,699. His evidence was less than clear. He said, "More or less, I gave her quote." It was clear he had no fixed price or price range as the project proceeded. Number 3. There was no form of written contract. This was a contract based on time and materials. Number 4. Based on the order, the plaintiff presented each 8 items claimed. I will review the facts and laws for each item. Items 2 and 8 are dealt together. Issues. Number 1. Popcorn ceiling. Both parties initially agree for the installation of some California ceilings. They require more labor than popcorn ceilings. Later on, the defendant and plaintiff agree to popcorn. Plaintiff denies that. Defendant notes that Jaw put the cost of the items at $860. At trial, he produced notes and said that a note dated July 23rd showed her agreement to the popcorn style. The ink is darker than the notes which appear above it. Obviously, this was added later. The question is when. He said July 23rd, but this is unclear where the date came from. During cross-examination, she testifies her ceiling is a mixture of popcorn and California. Number 2. Kitchen deficiencies. The item claimed at $1,400 in closing submissions, plus the materials dealt with at a cost of $668. The plaintiff photography evidence is compelling. The kitchen cabinetry was in shambles after assembly at the hands of Mr. Cosset. The entire job was found incompetently performed. The part of the claim is allowed in full against the defendant in the amount of $2,066. Number 3. The vanity. This was not done properly. Item was reduced to $68 in closing submission. Number 4. Paint repairs in the bedroom. Item is claimed at $296.58, but this item was not in fact performed. Number 5. Repainting walls in baseboard and caulking baseboards. Item is claimed at $1,489.99 based on estimate for work which has not been performed yet. Number 6. Sliding mirror doors. Plaintiff's doors were broken by the defendant's worker and in need of replacement. Number 7. Blinds. This item is claimed at $388.26, but this is not proved. Age of blinds nor the condition value at the time. Decision. Number 1. The popcorn ceiling. The damage is assessed for this item to be $300. Number 2. Kitchen deficiencies. The defendant and Mr. Cosset are jointly and severely liable for $2,066. Number 3. The vanity. The vanity is allowed in full. Number 4. Paint repairs in the bedroom. The item is allowed at the amount of $100. Number 5. Repainting walls and baseboard and caulking baseboards. This item is paid in the amount of $1,000 since previous claims seemed a bit high in comparison to other discounted work. Number 6. Sliding mirror doors. This item is proved at claim. Number 7. The blinds. Claim is accordingly dismissed. Rationale. Popcorn ceiling. The damages for this item have no relationship with the estimate to remove and reinstall because there will be no labor cost. Number 2. Kitchen deficiencies. Mr. Cosset is not liable for the breach of it. However, he is liable for his own negligence based on obvious shoddiness of his work. Number 3. The vanity. Based on photographic evidence of sloppy work, this item is proved. Number 4. Paint repairs in the bedroom. This is allowed in full since the job was not in fact performed like Issue 1. Number 5. Repainting walls and baseboard and caulking baseboards. Based on photographic evidence, painting and caulking was generally poorly done. Number 6. Sliding mirror doors. It is common ground that the defendant purchased lower quality replacement doors, but plaintiff does not accept solution. Plaintiff claims the replacement with doors similar to those that were broken in the amount of $590. Number 7. Blinds. Age of blinds nor the condition value is available at the time. Analysis. I believe that this was the right decision because the plaintiff paid for the labor and the materials and should be granted money if it was not performed up to standard. I believe he was charged rightfully and not overcharged since this was his fault, although lack of written contracts is a concern. And my survey question. Do you think Mr. Winnock was rightfully charged even if they did not have any written contracts?